Our Future on the Ballot, which is a series of interviews that we're doing with progressive candidates for office across the country. Today, we're featuring former San Francisco District Attorney and candidate for the Los Angeles District Attorney, George Gascón. He is challenging incumbent DA Jackie Lacey, who many grassroots advocates, including the Black Lives Matter Los Angeles movement, criticize for opposing progressive policies and reforms and failing to hold police accountable for acts of violence and dishonesty. George came to the United States from Cuba at the age of 13, moving to the Los Angeles area with his family. He joined the Army, he became a sergeant, and then a career LAPD officer where he rose through the ranks. He was, for a time, the police chief in Mesa, Arizona, where I am told he butted heads with Joe Arpaio, the famous sheriff there. And later, George was appointed to the post of San Francisco police chief and later San Francisco district attorney in 2011, where he implemented a number of reforms, including expunging cannabis records and arguing that practices like cash bail weren't actually good for public safety. George, thank you so much for being with us today.
My pleasure, Emily. It's good to see you.
Good to see you as well. All right, so let's talk about cops. You spent a lot of your career in policing, and your opponent, Jackie Lacey, says that makes your promises to reform policing ring a little bit hollow. She points to a decision from way back in 1999, in the 1999 police killing of Gus Woods, where you said that the officer involved did not violate LAPD use of force rules. Now, you've talked about how these attacks on your record are irrelevant to your positions that you hold now on policing in 2020. And you've also said that attacks like this suggest that people can't change over time. You said it's a very narrow way of thinking. So now, running as someone who's promising to reform the system and combat police violence, but also having this record of being an LAPD cop, I'm interested to know how your perspective on the role of cops has changed over the course of your career, particularly since this year's police killings of George Floyd and Breonna Taylor and the protests that we've seen across the country.
Yeah, Emily, really appreciate that question because it does speak to many things, right? It does speak to my own evolution. And, you have to go really far back to make the arguments that Lacey's making, given that I was the elected district attorney for nearly 9 years, prosecuting cops and holding cops accountable and really leading criminal justice reform. But even before that, if you look at my own history in LAPD, working with the U.S. Justice Department, consent decree, training, being considered, quite frankly, by many a disciplinarian under Bill Bratton, being the chief of police in 2 agencies where especially when it came to discipline, reforming discipline and actually taking a very active role at the way that we looked at police officer behavior. And interestingly enough, the case that Lacey picks, which I find fascinating because it is a case where a man had a weapon, he had a metal rod, and and we have this trial almost like a court martial for those in the military. We have 3 hearing persons, and in this case, we actually had an attorney who had done civil rights work because you have a civilian at the time and 2 sworn. And we learned during the discovery of this case that this officer had been provided training that, by the way, was mistaken. That somebody with a knife within certain distance, it would provide a threat of deadly force. And we confirmed that that officer received the training, which was not authorized training by the LAPD by the time that I was running training. And I made it very clear this was a unnecessary shooting, but I just didn't think that we could hold an officer accountable when we knew that supervision was providing training that actually led to that, certainly influenced that outcome. And one of the things that people will tell you across my career, both as a police officer and the prosecutors, is that I am a strong believer in providing people due process across the board. And frankly, the reason why I've become so much of a aggressive proponent of reforming police practices and use of force is because of the due process issue, because we have seen police continuously use deadly force in places where they shouldn't have, right? And I've always said that the question for police when they're using force is not whether they can, it's whether they should, right? And that's why I was the only district attorney in the state to actually fight to reform the state law to reduce the threshold where a police officer can use deadly force, where my opponent actually didn't. In fact, she complained that the law was prohibiting her from prosecuting cases. But then when I invited her to work towards the changing of the law, she didn't, which tells you that she was very comfortable with unnecessary police killings and continues to do so. Also, unlike her, as a district attorney, I never had a shooting of an unarmed person where clearly you couldn't make the typical argument that law enforcement makes that, I felt that I was threatened for my life or grave bodily injury or others. She's had, to her own account, over 12, I think it's actually more than that, of cases where people were clearly unarmed, and we know that because we have video and we have other evidence, and they kill someone, and she still found a way to justify the shooting. So the problem with Lacey is that she's trying to rewrite history in the last few months of a campaign and really getting desperate now and trying to be someone that she hasn't been for almost 8 years as the elected DA, but even before that, as the number 2 in an office that has been known to be one of the most punitive offices in the country.
So punitive, but perhaps not on police officers. And I want to turn to another aspect of that. This summer, it was discovered that LAPD officers were framing people for being gang members. There has long been criticism of California's gang database, which people have said contains the names of like 1-year-old babies and people who have no affiliation with gangs, just basically is not representative of actual criminal activity. And recently, it was discovered that these police were framing ordinary Angelenos and accusing them of being gang members when they, in fact, were not. So the LA County District Attorney's Office recently began backing away from the tainted cases that arose from those officers lying about people being in gangs, dropping cases that relied on these officers' testimony or relied on evidence brought by these police officers. So I think the question this raises, though, is that if these officers lied and framed people in this one context, the question is, can they ever be trusted as witnesses for the state going forward? So if you were elected DA and you were overseeing cases brought by officers in this police department and officers who may have lied on people in this way, would you rely on any evidence brought by the officers involved in this scandal?
Absolutely not. And this is the problem, again, that we have here. So I actually committed to not using gang files. I've been an outspoken critic of Cal gangs for quite some time. And then actually after I have made some of those assertions, then the scandal broke. But the problem is that the scandal cannot be taken in a vacuum, right? If we thought that was the whole problem was limited to those officers, the world will be okay, right? We just deal with those officers. The reality is that it's much broader. The problem, in fact, I was talking to a young adult today who, name not important because he's got a pending case, but was not a gang member. He happens to be a rapper. He happens to be black. And he got stopped. And just because of his rap music with no criminal history at all, and carrying a registered firearm and, carrying the firearm in the way that, should be carried. It was locked up in the trunk and, some other. And yet he was filed on for being a gang member because of some of his rap music and, quite frankly, no other reason he was black, right? With no other history. And the prosecutors actually filed the unlawful possession of a weapon with gang enhancements. And it really wasn't until a judge actually came to the conclusion that the officer was lying that the case fell apart. And, here is a person that could have faced, easily a decade by the time you add the gun possession plus the gang enhancements, if all that were sustained, simply because he happened to be black, right? And he was a rapper. So the problem with the gang files is it's corrupted in so many different levels, and it's not unique to the LAPD. And that's why I think it's important for us to get rid of Cal gangs altogether. And to the other point that you made, should people that now have a history of lying should they continue to be used? And absolutely not. In San Francisco, we created a no-call list, and we made the department know very clearly that we would not use those officers as material witnesses in any case. I think you really have to stop using those officers, not only for gang cases, by the way, but I worry that there's two things that are problematic in this case that you raised. Number one, and I know this because I know some of the lawyers involved on the defense side, they're basically they're putting the obligation on the defense and the person that was accused or convicted to go back and figure out if they were the victim of this, instead of them proactively going back and doing the hard work of determining all the cases that should be dismissed, right? Which we did that in San Francisco twice. It broke us. One time we had to look at over 1,000 cases, another time we had to look at almost 4,000 cases. Not easy, but you don't put that obligation on the defense, right? It is your duty to clean up the mess. Number two, this should not be segregated just to gang cases. To me, any work that this officer have done has to be placed under the microscope. And again, it's the obligation of the prosecutor to go back and clean up the mess, not to tell the defense, hey, by the way, you may have a problem in this case. If you find one, tell me. That's not the way to do it. Many cases you have people that were convicted that perhaps their lawyer may not be around anymore, right? The lawyer might have died, may have retired, may not be available. So where does that person go to for relief, right? Where's the obligation of the state to clean that up?
So George, let me just clarify for some of our viewers who might not be as steeped in this or weirdly obsessed with this as those of us in this room. You mentioned a no-call list. And for our viewers, I hope that I'm interpreting this correctly, that you're talking about when an officer is found to have been lying in a case, to have been what sometimes in the industry is called testifying or committing perjury, or engaging in dishonesty that makes them an unreliable witness. You're talking, I believe, about a public list of police officers who can't be trusted and whose cases should be essentially dismissed. Can you talk a little bit about what impact you think a no-call list has on the police department whose officers are being weeded out by it?
Look, I think first of all, for good police chiefs, it gives them the tool that they often lack to be able to take strong disciplinary action against some of those officers, because of all the protections that police officers have, even when they shouldn't be on the force. And I've had chief of police say, we would love to have that, because that gives me a leg on being able to be more effective in my discipline. Number two, I think it sends a very clear message across the board to police department, police officers. If you want to be a police officer, don't engage in misconduct, because if you do, you will no longer be able to exercise your trade, right? So it's sort of a deterrent, I believe. It's also a tool for the police department to do the work that they need to do. And, and more importantly, is the right thing to do, right? Is to ensure that our prosecutions are not tainted by people that are lying. By the way, and I really appreciate, Emily, you clearing up this up, because I do get sometimes so wrapped up that I forget that we're not necessarily talking to attorneys or even criminal attorneys, right? But the other component of this too is also people that have a history of bias or racism, right? Those are all disqualifying components for any witness that may be influential in how they came to doing whatever they did. In the case of police officers, making an arrest.
Okay, so I want to jump on this racism question, because if we're talking about disqualifying sources of evidence that might be racist or biased or dishonest or unreliable, I have to raise the question of facial recognition technology with you. The LA Times reports that LAPD or LA police generally used facial recognition software on Angelenos about 30,000 times over the last decade. And that's in spite of lingering questions about whether that's constitutional or whether it's even accurate, whether a machine can accurately identify a person from a picture of their face. So, and I mean like an extrapolation of their facial features. So my question for you is, knowing some of the flaws in this technology, would you ever rely on evidence based on facial recognition technology?
No, look, I think that this technology is still completely underdeveloped. And I don't think that the place to learn about this technology is in the criminal justice system, where you're sending people to prison and you're interfering with people's basic rights to freedom, right? technology is going to do what technology is going to do. I think that we as gatekeepers of the honesty of the system have to recognize that this technology is not ready to be used in this work, and it may not be ready, quite frankly, for many years. And it has no place in certainly in using it as evidence to support a prosecution. Frankly, I put this almost in the same place that I put single witness identification, right? We refuse to file cases on single witness identification, right? And I know the criminal justice system for years did that. And what we have seen over and over is a single witness identification often leads to wrongful convictions. Cross-racial single witness identification is extremely unreliable, right? We know that we as human beings are not very good at describing people from other races. So as a prosecutor, and this is sort of the science today as we know it. As a prosecutor, we have an obligation actually to use science to make sure that there's purity of the work. Facial recognition has not been proven yet to be to the level that I would say that is acceptable to be used in criminal cases. It may be used for other things. It may be used for marketing. I don't necessarily like the idea, but I get that, but it cannot be used for prosecutions of people today or leading to an arrest, just like we don't use single witness identification.
Thank you for that answer. Yeah, I think marketing, I know there are certain pairs of boots that are following me all over the internet, and I don't know how that happens. All right.
You walk into a store and says, she likes Gucci. The Gucci person comes right there.
Okay, so looking at other forms of technology, you just brought up this really great point, which is the sort of ethical duty of the prosecutor to determine what technology and what techniques are and are not reliable, and affirmatively refrain from using stuff that results in wrongful conviction. So I'd like to back up to earlier in the process, because conviction is the end game, right? It's the end of the case. But for many people, the most important moment in a case is right at the beginning. It's the bail question. People who get held in on bail are more likely to plead guilty to things they didn't do. They're more likely to say whatever they have to say to get out of jail. And people who are able to go through a criminal prosecution while still working, living in the community, being with their family, tend to have remarkably better outcomes. So the current San Francisco District Attorney, Chesa Boudin, has implemented a bunch of reforms surrounding bail, eliminating money bail, essentially the ability to buy your way to freedom and a better outcome. Now, you have long opposed money bail, and you say that if you're elected, you will work to eliminate it in Los Angeles. Some advocates in LA have raised an interesting question, which is whether if cash bail is eliminated and replaced with what are called risk assessments, basically algorithms that are designed to determine whether a person can safely be released, whether that's actually going to result in more people being held in jail. As we know, the data that these algorithms rely on is often really, really racially biased. Certain factors are dramatically more likely to flag as positive if you are Black or brown than if you're white. And as we all know about algorithms, junk in, junk out. You put racist data in, you get racist outcomes out. So I'm interested in how you are going to prevent pretrial detentions from increasing or becoming even more racist if cash bail is eliminated.
Yeah, and this is an area that, I think this is a perfect illustration of my own personal evolution. Okay, so in 2012, I was the first district attorney that said, we need to get rid of cash bail. And I started working with the Arnold Foundation, and this was very intentional. I did not want to go to a for-profit developer. We work with the Arnold Foundation, nonprofit foundation that does a lot of work in the space of criminal justice reform. And we work towards using their algorithms in order to get rid of cash bail. And in the San Francisco experience, by the way, actually, it lowered our pretrial incarceration significantly. But what I have come to the conclusion, again, in my own, just learning and working through this stuff, gets to the point that you're raising, that many advocates are saying, well, the problem is that these algorithms are only as good as the information that is fed into it. So while we did experience a reduction in pretrial incarceration in San Francisco, I've come to the conclusion that the technology is not there yet, right? So I think that the best way to do it, and I really like the way that Chesa did, and would be a very similar approach to what I would take, is first we'll take, automatically misdemeanors and nonviolent felonies, presumption of release, unless you can prove otherwise, right? And you move people on, you get them out of the system. Some people All they may need is to call their, the probation officer, call someone once a week or once, whatever. And that does the work probably for the majority of the people. For other people, there may need to be a more restrictive measure like ankle monitoring. But, again, I don't necessarily think that should be very limited, and it should be very, very clearly stated why. When you have cases where you believe that actually the person presents a risk, and you have facts that you can articulate to support that, what I've pledged to do is work with the defense and the bench, and we'll have evidentiary hearings, and we'll come up with a standard of proof. Perhaps it's clear and convincing evidence. However, we come to an agreement that if we have someone that we believe that should be held in pretrial detention because they're dangerous or they're flight risk, let's have a hearing. Now, obviously, as you well know, we still have to deal with some parts of the state constitution that provide a guarantee to cash bail in certain cases, and in others that prohibits it altogether. But I would say that I would begin by doing pretty much what Chase is doing, just basically clear the deck, certainly in all misdemeanors or non-violent felonies, and really start from a place of a presumption of release as opposed to a presumption of detention, and then try to come up with a way that is not necessarily relying on algorithms for those cases that we want to detain. That's kind of the journey that I want to take as we continue to evolve. Obviously, we have a ballot measure that is being supported by the bail industry right now, that I'm against it, because I don't believe that bringing back bail is the answer. The answer is, continuing to go down the path of no bail, but looking at the infirmities, such as the potential for algorithms to actually create more incarceration, and then looking for alternatives to that, but never going back to cash bail.
Got it. Okay, this is our last question. And thank you so much for spending this time to talk with us. We really appreciate it. I've got one more for you, and it's about really the feeling of safety in the community in Los Angeles. And I want to sort of flip the safety question on its head, because many people, when we talk about safety, they think of the police coming and making you safe. But in Los Angeles, as we've learned recently, the police can often make people dramatically less safe. Specifically, the case of 18-year-old Andres Guardado, who was killed by a member of a crew known as the Executioners. And when I say a crew known as the Executioners, I am not talking about a street gang. I'm talking about a sheriff's deputy gang, a gang made up of sheriff's deputies that exists within the sheriff's department. There was a whistleblower, Deputy Art Gonzalez, who came out and revealed that his colleagues had formed this incredibly violent gang that was killing ordinary Angelinos. So what would you do as DA to root out ideology that violent and that pernicious in a group of people that are supposed to keep the community safe?
Yeah, I mean, first of all, I think that we need to begin to have a different conversation about the definition of community safety and health, because, we have worked on almost on it in a definition that has been monopolized by police unions and prosecutors, with a very narrow view of what safety is, which goes to the point, over-policing many communities, where many communities actually feel unsafe to the point that you made concerning this shooting. I think the other part of it is that it's incumbent upon the district attorney, as sort of the gatekeeper in the system, to make sure that when there is allegations or potential criminal behavior within the system, meaning law enforcement, to proactively investigate and look into this matter, just like you would in any other, somebody was involving organized crime somewhere else, you would be very proactive there. You need to be very proactive when it comes to law enforcement too. And one of the problems that I see in LA County is we see the district attorney that has been so conflicted by the millions of dollars that she's taking from police unions that she continues to look the other way, not only to shootings, but to so many other things like the potentiality for criminal gangs within the sheriff department, or false information being provided in police reports, or false arrests, right? All these other things that are going on, that the district attorney is actually the one that should be rooting these practices out. That you have a district attorney that, because she's so conflicted by the level of resources that she's being provided, she continues to look the other way.
An incredibly disturbing thought. And I think a good place To close, thank you so much for joining us. It's been an absolute pleasure speaking with you. This has been The Briefing, speaking with George Gascón, who is running to be the next District Attorney of Los Angeles. Thank you so much for joining us. I'm Emily Galvan Almanza, wishing you all a good afternoon and a good night.